I will welcome you on behalf of the University of Southampton to this 40th Donald O'May lecture. My name is Mark Spearing. I'm the Vice President for Research and Enterprise for the university, which hosts the Institute of Maritime Law. I've attended several of these lectures in the past, and I've always found them fantastic events. They've always been very well attended. They've always had brilliant speakers talking about fascinating topics, and they have always been in amazing venues. And congratulations to the Institute of Maritime Law on picking a truly exceptional venue. I am quite intimidated just standing here. It's also wonderful to be fully back in person after the pandemic. I know there was a hybrid lecture last year, but it's really good to see so many of you here this evening. It's also a great pleasure to welcome you to this event, because not only is it the 40th Donald O'May lecture, but it represents 40 years of the existence of the Institute of Maritime Law, the organiser of the event. The Institute is very important to the University of Southampton. It is a very distinctive part of our university, and it has been for those 40 years. But it also has particular relevance at this moment in our history. We have just launched earlier this year a new university strategy. That strategy has as its founding principle a triple helix of our mission of education, research, knowledge exchange and enterprise, those three elements together. And I'd say the Institute of Maritime Law is a paragon of triple helicity. It embodies that bringing together of education informed by the research in maritime law in a way that through its knowledge exchange activities helps practitioners in maritime law make a difference in the wider world. Also, our strategy says that we are going to be very relevant to our city, and particularly we're going to be very relevant to the maritime industry as it confronts the challenges of being greener, being more sustainable in its operations. And through our Southampton Marine and Maritime Institute, we've been leading in this area for a while, with the colleagues from the Institute of Maritime Law very much part of that, and we look forward to build on that foundation to do even greater things over the coming few years. So I'm again delighted to welcome you to this 40th Donald O'May lecture. Many thanks to everyone who's attending, and particularly the sponsor of the event, INTS and Informa Law. Many, many thanks for your continued support. And I very much look forward to your lecture, sir. I'll now hand over to Professor Werner Scholz, the head of our School of Law, to say a few words on behalf of the school and the faculty. Werner.
Thank you very much, Mark, for your introduction. First of all, I would like to apologize on behalf of Professor Jo Swaffield, who is unable to attend. She had some delays with her train. So, yes, on behalf of Professor Jo Swaffield, I would like to welcome you, first of all, to this lecture, which is the 40th anniversary lecture of the IML, but also on behalf of the law school, where this institute is hosted. The second thing that I'd like to mention is I'd like to thank our sponsors, INCE from the shipping industry, as well as Informa from the publishing houses. They've sponsored and supported the IML throughout the past few years. The one thing I'd like to mention also is, as you all know, the IML is a foremost institute in maritime law. It is well known in academia, it is well known in the industry for its expertise and experience in the subject field. But the interesting thing is that the IML is also a very progressive institute that continues to grow and develops further. And to mention just one of the few interesting aspects is the launching of a bespoke online distance learning LLM program, which will commence 23-24. So that's a very interesting progressive aspect of the IML. The IML also has close connections with leading maritime lawyers, academics, maritime law associations, and international organizations based all over the globe. The Institute also maintains a specialized Philippa K. library, which hosts academics from all over the world, conducts research on a regular basis. The activities of the IML also include a number of esteemed activities, such as the IML Guard Fund, which was recently awarded and launched in October 2021. This important initiative has led to high-profile and important stakeholder workshops, such as the recent legal framework governing maritime labour and best practice drawing lessons from the post-COVID-19 era. The recent workshop, which was attended by a number, and I've attended one of the dinners, esteemed and reputable scholars and practitioners in the field. And this September, the IML has also led an international research and impact workshop on the topic Advancing Ship Autonomy. Once again, a milestone and an example of the work, the progressive work done by the IML. Well, I can go on for hours and hours about the activities conducted by the IML, which I won't do. But looking forward, next month, the IML will culminate its celebrations of this milestone of 40 years with an international conference to be held in Southampton. And this event is the last event organized by our current director, Alexandros. And Alexandros, on behalf of the school and the Faculty of Social Sciences, I would like to thank you for your guidance, leadership, and support of the IML. Thank you very much. Your tenure will end January 2023, and Professor Andrea Lister will be the new IML director. Congratulations, Andrea. Looking forward to the work that we will do and to continue with the work that has been done. So on that point, I'd just like to thank Alexandros, but not only Alexandros, but the whole team of the IML, Claire and other colleagues of the IML, for the wonderful contributions that you've delivered over the past years. And now, without further ado, I will hand over to our current IML director, Alexandros. Thank you very much.
Good evening to all, and welcome to the 40th installment of the annual lecture in Maritime Law. My name is Alexandros Dovas, and I'm Director of the Institute of Maritime Law at the University of Southampton. I'm delighted to open the substantive part of the Institute's annual lecture dedicated to the memory of Donald O'May, and thank Beryl and Neil for their attendance this evening. This is the last annual lecture in my present role, as I will soon complete my 3-year tenure as the Institute Director. At the time when I came into this position, in January 2020, the spread and pace of the coronavirus disease started steadily to evolve to what shortly after was confirmed to be a full-scale pandemic with unprecedented impact on the global population and the world economy. However, against the adverse conditions, the Institute adapted immediately to the new circumstances and remained undeterred from the aim of being a major center for research, study, and dissemination of maritime law, enjoying an international reputation for excellence. It is notable achievement indeed that this year the Institute celebrates 40 years uninterrupted activities at global engagement and activities in pursuit of our specialist activities in research, teaching, and enterprise in maritime law. The legacy of 40 years will not have been, however, possible, of course, without the support throughout this time from the industry network, the academic setting, and the University of Southampton. I would like, therefore, to thank the Vice Chancellor and President of the University, Mark Smith, the Vice President of Research and Enterprise, Professor Mark Spearing, our Dean, Professor Joe Schofield, and Professor Jane Falkenham, now the Vice President of International Engagement, Professor Sabu Patmadas, the Associate Faculty Dean International, and of course our Head of the Law School, Professor Werner Scholz, and his predecessor, Professor Brenda Hannigan, for all of their great support. I'm confident that the Institute will be led effectively into its 5th decade by my successor in this role at the end of January 2013, Professor of Maritime and Commercial Law, Andrea Lister. In closing my short introduction and having the honor and the privilege to serve as the director during the 40th anniversary lecture. I wish, of course, to acknowledge with appreciation and express the gratitude of the Institute and the University for the generosity of our sponsors, INSE and Informal Law. Please allow me to extend a more personal thank you to Tim Hose from GARD, Michael Volikas and Julian Clark from INS for the untiring support and always steadfast advice in organizing the lectures over the last 3 years. Finally, a thank you to all the members of the IML, past and present, our colleagues forming the indispensable administrative apparatus, Claire Auld, Sarah Lebar, Natasha King, Laura Armstrong, and many other colleagues that have served in that role. And for all of you for joining us this evening. Above all, I would like to thank God for the strength and patience bestowed onto me during this time of service to the Institute. Without further ado, I shall pass now the floor to the chair of the annual lecture for this year, Julian Clark. And Julian does not need any particular introduction. He has been described as being a major scholar in the maritime law industry. He's a leading authority, in particular for sanctions in very difficult situations. But an information that I was just last night privileged to disclose is that also Julian is leading a very upcoming, if I may use this term, band, folk rock band called Love Street, with a significant playtime on BBC radio, and I will encourage you to look them up on Spotify. Julian, thanks so much for chairing the panel tonight, and a personal thank also to Andrew Kennedy, our speaker, and our thanks and congratulations also to the vote of thanks provided by David Stewart, who is the newly elected president of the London Maritime Arbitrators Association. Thank you.
Thank you, Alexandros, for those very kind words. In case anybody is wondering, of course, copies of the album and merchandise will be available at the back of the auditorium. It's a great honour for me to be here. It's quite strange being back in this hall after, I think, about 35 years. I explained to my head of shipping, Michael Volikas, just when we were having drinks prior to coming into the hall, that I think the last time I was in this hall was 35 years ago, sitting my family law exam when I was reading for the bar. So these are slightly different circumstances. But it is a great honour for me to be once again asked to make this opening address at this, the 40th Donald O'May Lecture. If the maritime profession had a Hollywood-style recognition of the talent and contribution to our sector, tonight, ladies and gentlemen, would be the Oscars. The list of previous speakers is an assembly of the very best in our sector, and tonight's speaker is no exception to that tradition. We are once again honoured tonight to be joined by Beryl and Neil O'May, the wife of Donald and his son. And as many of you know, Donald was the senior partner of INS from 1976 till 1988. He is a man that truly needs no introduction. A true giant of the law. A man that placed his stamp of justice, integrity, and the importance of heritage upon INS. And long may that tradition continue. He was a skilled and foresightful practitioner in the field of insurance law, and for many, both members of our own judiciary and those involved in the practice of maritime law, both in this jurisdiction and internationally, a guiding and leading light, and continues to be so. I am truly humbled to be the current senior partner of Ince and to sit in the chair previously occupied by Donald. It's also, of course, fantastic to be holding this lecture once again in a physical format, and so good to see so many familiar faces and new faces here tonight. And what a time this is that we find ourselves in. The resurgence of our shipping markets, possibly the best time that some of our owners have seen since the crash in 2008. But in counterbalance to that, we are facing a number of significant challenges. Political instability, the unlawful invasion of Ukraine, and global challenges to the rule of law. And despite all the great good that we've achieved in making our sector safer, our seafarers still suffer. And the latest example of that being the appalling treatment, quite frankly, of the crew of the heroic Aiden. And our hearts and support go out to the crew of that vessel and to their families. But for tonight, our focus is on the common law and civil approaches to a duty of care, a classification society's perspective and comparison. I am therefore delighted to introduce tonight's keynote speaker, Andrew Kennedy of Lloyd's Register and the Head of Dispute Resolution and Compliance. A few words about Andrew for those that don't know. Andrew was called to the bar in 1987. That's a year before I was called, so I am truly Andrew's junior tonight. Andrew practiced in criminal and general common law before joining Lloyd's Register, but in his time at Lloyd's Register, Andrew's successes and work have been quite phenomenal. He successfully managed the defence of claims exceeding £4 billion in over 30 jurisdictions. He's worked with the leading maritime lawyers across the world and in major UK public inquiries, including Piper Alpha and the Derbyshire inquiry. He's also seen through formal investigations in civil law jurisdictions, most notably the joint Danish, Norwegian and Swedish inquiry following the arson attack in 1990 on the Scandinavian Star, which of course, as you will know, many of you, that tragically resulted in the loss of 159 lives. But which partly, due to the work of Andrew, led to improvements to the regulation of safety of shipping. And he's also worked on the 2013 Dutch parliamentary inquiry into the Feyre high-speed rail project. Andrew has represented Ajax and the Lloyd's Register in Brussels when the EU were modifying the statutory regime for classification societies and oil tankers in the light of both the Erika and the Prestige oil spill disasters. And as well as that, Andrew has served as the chair of Ajax Expert Law Group, has been the president of the Quality Assurance and Classification Entity QACE for EU recognised classification societies, again established under EU law in the wake of the Erika and the Prestige oil pollution disasters. He's also a non-executive director of the Institute of Maritime Law at the University of Southampton. Andrew, the floor is yours.
Well, thank you very much, Julian, for that introduction. And I just want to reassure everybody that I don't have any music to sell later on. I'd also like to thank the Institute of Maritime Law for the invitation to speak to you this evening. I found it was a great honour and privilege to be invited because it gives me the chance to take you on a voyage through the work that I've been doing throughout the course of my career and talking about duty of care and how it's approached in the different jurisdictions that I've worked in. And like Julian, I feel as if I've in some ways gone full circle. The first time I was in this hall was as a young undergraduate, brought up to legal London for the first time, and they said to us, "You're going to have lunch in Lincoln's Inn." And I think I envisaged some type of canteen until we were swept in here and brought up to the top table. right where that table is this evening. And there were a number of empty chairs. Students all sat down. I had an empty chair beside me. And then senior members of the judiciary trickled in from the RCJ for lunch. And suddenly, the seat beside me was occupied by Lord Denning. So we had an incredibly interesting lunch, listening to all their stories about starting out in practice just after the war in the 1950s, some of them, and also literally war stories from their time on the Normandy beaches and battles in Europe. So I don't know whether my talk is going to be, I doubt my talk is going to be as interesting as that, but anyway, here goes. I'd like to start by speaking about the Morning Watch case, a case that concerned this motor yacht, and it was built in 1962 by Ailsa in Scotland, and it was classed with Lloyd's Register under the terms of the Lloyd's Register classification rules and regulations, and I'll refer to those as the rules as I go through the talk. And Lloyd's Register, along with other leading societies, of course, through all its technical expertise and knowledge, produces safety rules governing the design and construction of vessels. So this motor yacht, built to those rules, was put on the market for sale in late 1984, at a time when Lloyd's Register was conducting its special survey of the vessel. It has two decks, the main deck and the upper deck, both steel decks covered in wood. And on completion of the special survey in November 1984, Lloyd's Register issued a condition of class, a certificate of class, which contained a few minor conditions, nothing to do with the main decks. 3 items that were required to be repaired to the satisfaction of the surveyors by the end of February 1985 for the vessel to remain in class. At the time of Lloyd's Register's special survey, Lloyd's Register knew the vessel was to be offered for sale, but not who the purchaser was. There was no correspondence between Lloyd's Register and the purchaser, Mariola, until the delivery date. The brokers appointed by the seller advertised the vessel as having passed special survey in November 1984 with no difficulty. The purchase by Mariola was completed on the 18th of March 1985, and on that date the wealthy American beneficial owner, Mr. Steinforth, wrote to Lloyd's Register requesting a deferment of repair of the 3 minor items which had been noted as conditions of class, pending refit work scheduled to be carried out on the vessel in Gibraltar. When the vessel was being refitted in Gibraltar, a large area of corrosion requiring steel replacement, unanticipated by the buyer, was discovered, which added almost £100,000 to the cost of the refit. And it was that additional cost which was the subject of Mariola's claim, and came to be considered by Mr. Justice Phillips, as he then was. And of course, he went on to become first president of the Supreme Court of England and Wales. And he dealt with the case on the basis that he noted the primary purpose of Lloyd's Register is to enhance the safety of life and property at sea, rather than to protect the economic interests of those involved in shipping, referenced in Lloyd's Register's constitutional objects. In his judgment, he found that there was extensive and serious corrosion of the boat and main deck, and that the Lloyd's Register surveyor had failed during special survey to exercise the standard of skill and care expected of Lloyd's Register surveyors, and to use the discretion expressly vested in Lloyd's Register surveyors by the rules to call for additional opening up and lifting of deck timbers. However, despite that, he ruled that Lloyd's Register owed no duty of care to Mariola. And in coming to that conclusion, he considered the tests of whether it was foreseeable by Lloyd's Register that Lloyd's Register's negligence would cause Mariola the damage claimed. He held that it was reasonably foreseeable that Mariola would rely on the result of Lloyd's Register's survey, but that in itself wasn't enough to establish a duty of care in a case of economic loss. The second test he applied of proximity was whether the relationship between Lloyd's Register and Mariola was sufficiently close. And he noted that there was no relationship between the two with sufficient proximity to form the basis of a duty of care in negligence existing between Mariola and Lloyd's Register. And on the third test of whether it was fair, just and reasonable, he didn't answer the question, but noted again that the primary purpose of classification was to enhance the safety of life and property at sea rather than to protect the economic interests of those involved in shipping. A few years after Morning Watch, cargo interests commenced a claim against the Japanese Classification Society, NK. This was a seminal case in England which considered whether a class society owed a duty of care to cargo interests. The cargo interests in this case found themselves substantially out of pocket following the loss of the bulk carrier Nicholas H. as it crossed the Atlantic fully loaded from South America, heading for Italy and the Black Sea. After leaving South America, the ship developed a crack in the hull and made for anchorage off Puerto Rico. Classification rules and insurance terms typically require such damage to be reported by the owner's representatives, and Class NK sent their local non-exclusive surveyor on board on the 25th of February 1986. He recommended that the cracked area be examined and repairs be completed. And the implication of that recommendation was that the ship should be dry docked and cargo offloaded. That would have been possible in Puerto Rico, but expensive. So the owner sent a riding crew to the vessel who carried out temporary repairs at anchorage. The Class N surveyor was then called back on board, and on the 2nd of March 1986, he issued a second certificate of class, accepting that the vessel could continue its Atlantic voyage in NK class with a revised condition that the vessel be further examined on discharge of cargo in Europe or within 3 months. The next day, on the 3rd of March, mid-Atlantic, the welding of the temporary repair cracked, and on the 9th of March, the vessel sank. All the crew safely evacuated, and there was no injury or loss of life. Bishop Rock, as the registered owner, paid the cargo claimants $500,000 in compensation for a cargo valued at over $6 million, and on the basis of the limitation of the owner's liability in the relevant international convention and contract terms for carriage of cargo agreed between the ship owner and the cargo interests. London's Commercial Court, in hearing the case, assumed that it was reasonably foreseeable to Class NK that the cargo damage was a likely consequence of NK's negligence during survey. So the case turned on a preliminary issue. Given those accepted facts, did NK owe the cargo interests a duty of care and tort? In the Commercial Court, at first instance, the finding was against NK, but this was overturned unanimously in the Court of Appeal. And Lord Justice Saville stated it would not be fair, just and reasonable to impose a duty of care on Class NK. The case then went to the House of Lords, and Lord Justice Stein, in the leading judgment, agreed with the Court of Appeal. He noted the role of Class NK was to provide for the safety of life and ships at sea in the public interest. He declined to impose a duty of care on NK, and he stated, if a duty of care is held to exist in this case, the potential exposure of classification societies to claims by cargo owners will be large. That greater exposure is likely to lead to an increase in the cost to classification societies of obtaining appropriate liability risks insurance. Given their role in maritime trade, classification societies are likely to pass on the higher costs to owners. Moreover, it is predictable that classification societies will require owners to give appropriate indemnity. Ultimately, ship owners will pay. The result will be to enable cargo owners, or rather their insurers, to disturb the balance created by the Hague-Visby rules, as well as by tonnage limitation provisions, by enabling cargo owners to recover in tort against a peripheral party to the prejudice of the protection of the ship owner under the existing system. For these reasons, I would hold that the international trade system tends to militate against the recognition of the claim in tort put forward by the cargo owners against the classification society. And as I contemplate that ruling and those words against the involvement of Lloyd's Register with approximately 7,000 vessels worldwide, and try and calculate the total value of the cargoes on board those vessels, it runs into billions. And I can understand in that context why Lord Justice Steyn came to the decision that he did. And those two authorities of Morning Watch and Nicholas H. were embedded further by the cases of Riemann, Philcox and Perrott. Riemann concerned a trawler which had been certified on behalf of the UK Department of Transport following an error made when assessing the fishing vessel's stability and metacentric height. It meant, when the error was spotted, that the fishing vessel was virtually unusable. It was devastating to the business plans of Mr. and Mrs. Riemann. However, again, the English courts declined to impose a duty of care for these economic losses on the inspector, following the principles of Morning Watch and Nicholas H. Philcox was a claim made by the owner of a small aircraft certified by the Civil Aviation Authority under the statutory safety regime and damaged in a crash. It was found there had been an error made in a fuel tank gauge, which meant it did not show empty. In flight, the plane ran out of fuel, lost power, crashing in 4 to 5 feet of water, having cartwheeled close to the shore, with Mr. Philcox and a passenger inside. Perhaps miraculously, neither were injured, and the case was dealt with as an economic loss claim. And based on the maritime authorities, it was determined the CAA did not owe the owner of the plane that crashed a duty of care in relation to the economic losses related to the repair of the plane. That can be contrasted with the subsequent Perrott judgment. In Perrott, the plaintiff, a passenger, suffered injury when a light aircraft crashed. He sued Mr. Collins, the owner of the craft, and the second defendant, who had inspected the craft on behalf of the third-party defendant, the Popular Flying Association. The second defendant knew the gearbox had recently been changed when he was carrying out the inspection, but did not pick up that the propeller had not been modified as it should have been, and that ultimately caused the plane to crash. Mr. Perrott, who claimed damages for his personal injuries, was held to be owed a duty by the inspector, it being deemed in this case fair, just and reasonable that Mr. Perrott should be compensated for his personal injuries. A few years later, in the United States, there was a claim brought by the buyer of this high-speed passenger vessel, the Speeder, by the US purchaser Otto Candies. The vessel was sold by an owner who had operated the ship in Japan under the Japanese flag, where it was classed by the Japanese Classification Society, NK. When it was put on the market in 1998, NK class was removed. And on the 22nd of December 1999, Otto Candies signed an agreement to buy the vessel on condition that NK class was restored before delivery, free from recommendations for repair of defects. On the 5th of January, NK issued a classification certificate restoring the ship's NK class without any recommendation for repair, and the ship was delivered to Florida. On delivery, Otto Candies applied to transfer the vessel's class to ABS, and the ABS surveyor attended and issued a report with a list of significant defects requiring repair before the vessel could be ABS classed. Otto Candies claimed the cost of making these repairs of $328,000 from NK, and the US First Instance Court found NK liable for negligent misrepresentation, and the case was then appealed. On appeal, the appeal court agreed that it was right that NK had a liability, as it knew its certificate was intended to be used to guide Otto Candies' decision to purchase speeder and accept delivery of the vessel, and given the fact that the defects reported were found to be breaches of NK's classification rules. The Fifth Circuit US Court of Appeals, in upholding the findings of liability, issued, however, the following caveats. We emphasize that a claim for negligent misrepresentation in connection with the work of maritime classification societies should be strictly and carefully limited. The Society's surveys and certificate system are essential to maintaining the safety of maritime commerce, yet their activities should not derogate from the ship owners and charterers' non-delegable duty to maintain seaworthy vessels. Imposition of undue liability on classification societies could be harmful in several ways. The societies could be deterred from the prospect of liability from performing work on old or damaged vessels that most need their service. The spreading of liability could diminish owners' sense of responsibility for vessel safety, even as it complicates liability determinations. Ultimately, broader imposition of liability upon classification societies would increase their risk management costs and rebound in higher fees charged to the society's clients through the maritime industry. Whether such risk spreading is cost efficient in an industry with well-developed legal duties and insurance requirements is doubtful. So the reticence to impose large financial liabilities on class societies may be also illustrated with reference to the case in which Lloyd's Register was involved in the United States concerning the Petroleus platform. This was a platform in the Gulf of Mexico with a topside structure in two modules. The modules were lifted into place by the Lloyd's Register class Derrick Barge 50, a heavy lift crane barge. The first lift went well, the second lift did not. The main hoist snapped, and a module that had cost $120 million to design and build dropped into the Gulf of Mexico. The whole project was insured under a construction all risks policy, but that didn't stop third-party claims against Lloyd's Register from the CAR insurers and also from the project owner. And in addition, there was a claim brought by the owner of the DB50 barge for the $120 million that it cost to replace the topside module and an additional $350 million in damages suffered by the insurers. In that case, the allegations were that the Lloyd's Register annual survey just prior to the casualty had failed to spot corrosion in the wire rope. Lloyd's Register charged just under $2,500 for that survey. And those of you familiar with US litigation will know the discovery process in a case like this, which can involve many witnesses, dozens of witnesses, and hundreds of thousands, if not millions of documents. And during the discovery process, Lloyd's Register was very keen to try and find a photographic or a film record of what had happened during the lift. All the time, we were being told there was no such record until one of our defense attorneys in New Orleans went to the dentist one day, and sitting in the waiting room of the dentist, another patient came in and they struck up a conversation, and he asked her, when he heard she was an attorney, if she was involved in any interesting cases at the moment. She mentioned this case, and he said, well, I know all about that because I was on the DB50 when it happened. And he said, you know, I had my camcorder with me and I recorded the whole thing. So we were then in the fortunate position that this chap agreed we could see his film. And when we looked at his film and listened to the soundtrack, because very fortunately for us, when he filmed it, he was standing right next to the barge captain, who was on the walkie-talkie speaking to the crane operator. And one of the things Lloyd's Register did in certifying, classing and approving this vessel was to approve and stamp the loading manual as approved. And this was the key page from the loading manual, which showed that this main hoist, when it was being used with the crane jib in this angle to accommodate the dimensions of the module, could lift a maximum on this axis of 3,200 tons. As we could hear the soundtrack on the film, actually the crane ended up lifting 3,000, somewhere north of 3,600 tons. Once we had that witness come into court and take the judge through the film and the transcript of the film, the case against Lloyd's Register, fortunately for us, collapsed. But the financial amount of that claim for a survey of $2,500, I think, illustrates the good sense of Lord Justice Steyn and others who say that these liabilities should not rest with the safety regulators. So moving on to the civil law jurisdictions, and I put up on the screen the codified provisions which enunciate in very general terms the basis upon which a legal duty will be owed to third-party claimants. There's a great similarity, of course, between the French provision, the Italian provision, and the Dutch provision. And I think I was listening to Andrew Roberts, the English historian who's published a biography of Napoleon, saying that he thought Napoleon's greatest achievement was the codified legal system, which he introduced to Europe and rolled out across the world to other places as well, with these codified provisions. And as we shall see from the cases that I've been involved in, these general provisions, when they're considered against what classification and safety inspectors in civil jurisdictions have been doing, there is very careful consideration usually given by the courts to elements of fault and causation and reliance and foreseeability. And I wanted to mention that, first of all, in relation to this case concerning this vessel, this general cargo ship, the Junior M. This was a vessel that in 1999 in LR class loaded a cargo of ammonium nitrate in St. Petersburg and left bound for Morocco. In the English Channel, the ship developed a pronounced list, and soundings indicated there was seawater in number 1 cargo hold. The ship was granted refuge in Brest, and the damaged cargo was offloaded. Sharaf, representing the cargo interests and their insurers, AXA Maroc, claimed €300,000 for the damaged cargo from the ship owner, but also Lloyd's Register. A court expert was appointed and naval divers instructed to carry out an underwater examination. They found 2 holes in the hull. One had been plugged with rag and the other with wood. And there was also a corrosion in the sump at the bottom of a number 1 cargo hold above the number 1 port ballast tank. On that basis, the French court expert condemned the owner and Lloyd's Register. The appeal court in Rennes agreed on the basis of an assertion by the court expert that Lloyd's Register should have done further surveys of the ballast tanks at annual survey in 1999. Lloyd's Register's contention was that it had no obligation to do surveys that are not required by the terms of Lloyd's Register's rules. And Lloyd's Register pointed to the documented evidence that during the more detailed special survey of the vessel in 1998, all the ballast tanks had been surveyed in accordance with the rules, and no holes of the type observed in October 1999 had been reported in 1998. In this French Supreme Court, the Cour de Cassation, Lloyd's Register was exonerated and the Rennes judgment was rendered null and void because the Supreme Court found that there was no evidence presented of Lloyd's Register surveyors breaching relevant Lloyd's Register survey requirements published in the classification rules. We've also, from time to time, faced claims made by charterers. And in relation to this vessel, Redwood, which was detained by Port State Control in January 2003, a Genoese charterer claimed for losses following that detention. The detention occurred at the time the claimant charterer was loading a cargo of milk powder on board. The loading had started on the 18th of January 2003, and when the vessel was detained on the 21st of January, the charterer hired another ship at additional costs and had then additional costs of loading and unloading, a total amounting to just under €1 million. Initially, Lloyd's Register was found liable by the First Instance Court in Genoa, but on appeal, Lloyd's Register argued successfully that there was no evidence the charterer had relied on Lloyd's Register, and therefore insufficient evidence that Lloyd's Register had caused the charterer's loss. Lloyd's Register pointed the court to the charter party dated the 14th of January, which was unsigned and did not require the vessel to be classed. In response, the charterer's lawyers produced a printout from the Lloyd's Register website of the classification status of the vessel, stating it was Lloyd's Register classed, but that was dated the 23rd of January 2003, after the date on the charter party, after the date when the charterer had started loading, after the date when the vessel had been detained, and therefore couldn't have caused the charterers to be misled. And the Court of Appeal agreed. The case then went to the Italian Supreme Court, where an argument was made that there should be some, under Italian law, there should be some form of new social contract recognized between a classification society and the charterer. But the Italian Supreme Court declined to agree to that and found in Lloyd's Register's favour. I'd like to move on to a non-shipping case, but one that was influenced by shipping in the Netherlands. This is a Yankee dryer, which was a large steam roller in a paper mill in Holland, which was licensed and certified and inspected by Lloyd's Register Netherlands under the provisions of the Dutch Steam Code. The owner of the paper mill, MME, modified the Yankee dryer by engaging a German company, PAMA, to attach a new metal groove to the edge of the Yankee dryer to assist with paper mulch being rolled under the under the steam vessel. And it was argued following this vessel cracking in service in September 2005 as they pumped steam in to start up the system again, and there was an issue about whether they did that too quickly. Our contention was that they had done. So there was a claim made for €12 million by MME, initially against PAMA in Austria under the terms of the MME and PAMA contract. In response to that, PAMA then commenced proceedings in Holland against Lloyds Register Netherlands, arguing that Lloyds Register Netherlands had incorrectly agreed to this modification in breach of the Dutch Steam Code, and asked the court for a declaration that if PAMA was found liable in Austria, that Lloyds Register Netherlands would be required to indemnify PAMA by the Dutch court. And the Court of Appeal, who came ultimately to deal with this in The Hague, noted that the express purpose of the Dutch Steam Act was the protection of general safety, and Lloyds Register's involvement was mainly intended to contribute to the increase of public safety and public health, and was expressly not intended to protect the economic interests of entities like PAMA. And it determined that this Dutch Steam Act did not serve to protect against the financial damage which might be suffered by PAMA, and noted that PAMA did not have a contract with Lloyds Register Netherlands and declined to issue any declaration that Lloyds Register Netherlands owed PAMA a duty of care. And that decision of the Hague Appeal Court was based on an inland waterway vessel case where the Dutch flag inspector was sued for damages as a result of a Dutch barge sinking, and the Dutch Supreme Court, for the very similar reasons to the Hague Court of Appeal in this case, declined to impose a duty of care in that case. I think courts in different jurisdictions can often adopt a very similar approach, and that's illustrated by the Mobile Berrelay case. This was a case involving a Lloyds Register classed and certified single point mooring, which was operated by a UK mobile company. It was used to draw oil from subsea wells and pipe through this SPM to tankers. It ruptured after 10 years' service in the UK and Scottish EEZ. It was unclear if damage in service or alleged CFEM construction and design errors had caused the loss. LR defended the claim brought by Mobil in relation to the design and construction work on the basis that LR's work during construction was done not for Mobil but under contract to CFEM. And we argued as well that as the structure was operated and had collapsed in the Scottish EEZ, and construction and survey work had been done in a number of other jurisdictions, Scottish law and the principles of Nicholas H. should be applied, and there was insufficient proximity in the case between Lloyds Register and the Mobil UK company at the time of the construction surveys. The French Supreme Court agreed with that, despite protestations from Mobil's avocat that Anglo-Saxon principles should not be heard in the Cour de Cassation. That was rejected. Of course, these cases don't mean that surveyors conducting safety surveys are immune or protected or don't have any liability. And an example of a case where a surveyor was held to account for improperly carrying out a survey is the Korean ferry disaster Seawall. This vessel was operating in Korean territorial waters, so it was subject to the Korean safety regime, but that required an inclining experiment. And a Korean register surveyor carried out a survey of the experiment. He was found by the Supreme Court in Korea in 2018 to have signed a false inclining inspection report without verifying the capacity of the tanks by sounding, without checking the weight and position of the test load and the arrangement of the test load, without measuring the draft before the inclining inspection and checking that that was the same as the draft after the inspection, And he was found and convicted of a criminal conduct, and he was sentenced to 1 year in prison and 2 years probation. So the economic loss cases I mentioned don't mean that surveyors have any immunity and can rest easy. And in my experience, they're acutely conscious and aware of the fact that they have a tremendous responsibility when they come to issue the safety certificate on a ship that's going to be carrying hundreds or thousands of passengers or enormous cargoes. There is, at the moment, as some of you may know, a case which has gone from the European Court back to the Italian Supreme Court over whether or not RINA can be sued in Italy as a result of this 2006 casualty when the Al Salam Boccaccio capsized in the Red Sea and over 1,000 passengers perished. There have been legal proceedings and a legal inquiry in Egypt, but the victims commenced a legal claim in Italy, and initially the Italian courts rejected jurisdiction on the basis that as it was a Panamanian flagged vessel, the Italian courts didn't have jurisdiction to hear matters relating to those representing the Panamanian authority. That was referred to the European Court of Justice, and the court held that whilst there is a procedural bar which prevents the courts of one state from giving liability on judgment on liability of the representative of another state performing a function of that state, it's not absolute and may be excluded if the legal proceedings relate to acts performed which don't fall within the exercise of the state's public powers. And the ECJ, in the ECJ's view, they held that the relevant provisions of the Council Regulation number 44 of 2001 on jurisdiction and the recognition and enforcement of judgments in civil and commercial matters must be interpreted as meaning that an action for damages brought against private law corporations engaged in classification and certification of ships on behalf of and upon delegation from a third state falls within the concept of civil and commercial matters, and therefore within the scope of that regulation, provided that classification and certification activity is not exercised under public powers within the meaning of EU law, subject to the national court determining that, the national court would have jurisdiction. And the case went back to the Italian court, who have decided that they have jurisdiction to hear the case. And I'd just like to conclude by mentioning two seminal oil pollution cases. One, the Erica, where the Classification Society was found to have a joint and liability with Total, and the other, the Prestige. And the Erica case, first of all, just to summarise, was a 25-year-old tanker which sank in relatively shallow water in December 1999 in RINA class. Some 400 kilometres of shoreline were polluted by more than 250,000 tonnes of oily waste. RINA was convicted by the Italian court on the 16th of January 2008 of acts endangering people in breach of articles of the French Penal Code. It was also convicted of blatant recklessness and negligence causing pollution over French territorial waters, and a fine was imposed of €375,000. For acts subsequent to the 1st of August 1999, RINA SPA was jointly sentenced with Total and the owner's representatives to pay €204 million in compensation for the pollution clean-up costs and associated damage. Although RINA appealed to the Paris Court of Appeal, the appeal was rejected. And I think it's important in reviewing these judgments of the French courts in this case to take account of the fact that the findings were based on a February 1998 RINA condition survey at a time when the vessel was Bureau Veritas classed. During that survey, RINA found very extensive corrosion of the main deck, which caused the attending surveyor to state, "The ship is not acceptable for Rena class takeover unless the following work is achieved." And the list of works included replacement of all deck plates, over which was observed local and extensive corrosion. On the 16th of June 1998, the owner's representatives then sought Rena classification whilst the ship was in a Montenegrin repair yard undergoing special survey by Bureau Veritas, and Bureau Veritas' certificate of class was due to expire 7 days later on the 23rd. Rena's surveyors arrived on the ship on the 23rd, by which time no steel deck replacement work had commenced. Then, under contract to the ship owner, 7,842 thickness measurement readings were reported by a thickness measurement company, Paulillo. The court experts who investigated found that Paulillo's thickness measurement results, compared against Rena's regulations, would have required replacement of 209 tons of steel, of which 81 tons were on deck, whereas the repair records indicated that only 34.5 tons of steel were replaced, of which 16.1 tons were on deck. The ship left dry dock in July 1998, and Rena surveyors issued an interim certificate of class, which was replaced by the full Rena classification certificate in September 1998, following review of the survey by Rena's head office. In November 1999, 2 weeks before this casualty, Rena conducted its annual survey. The court found that during that, the Rena surveyor observed diminution in thickness of steel on the deck and recorded thinning of the starboard deck framing in way of starboard number 2 ballast tank, as well as other corrosion in way of the deck structure. However, the Rena surveyor did not have any measurement of the extent of this corrosion taken. The court found that if he had done so, the corrosion in breach of Rena's rules would have been discovered, and Rena's classification would not have been renewed approximately 2 weeks before the casualty. In addition to those findings, the French court and its technical experts had deck wreckage raised, and they were able to examine part of the plating between frames 66 and 74 on the deck, as well as a piece of wreckage picked up by a trawler. All of these parts, measured for the purposes of the French proceedings, showed significant corrosion of the structures, which were stated by the Paulillo thickness measurement company to be only slightly oxidized. The court finally noted that Paulillo's measurement report recorded thicknesses of structural members that did not exist on Erika, thicknesses 6 to 9 millimeters greater than original thicknesses reported, some deck plate thicknesses greater than those measured in a previous survey in 1993, and that the number of measurements per man per day appeared impossibly high. So it's not surprising that the findings of liability came against that background, and the Paris Court of Appeal ruling that there had been unforgivable wantonness or recklessness, which was at the origin of the disaster. And then finally, maybe to contrast that case with the Prestige, just a brief recap on the circumstances of Prestige. The Bahamian vessel sank in November 2002, and around 141,000 tons of oily waste was collected along the Spanish shore. The Spanish state then sued American Bureau of Shipping, ABS, initially for $5 billion. They reduced it along the way to $2 billion. And that proceeding ended in 2012 with the US Court of Appeals Second Circuit ruling. And that ruling was based upon a consideration as to whether Spain's claims against ABS were covered by the provisions of the Civil Liability Convention, and in particular Article 3, 4b of that convention, which provides that no claim for compensation for pollution damage may be brought against the pilot or any other person who, without being a member of the crew, performs services for the ship, unless the damage resulted from such person's personal act or omission with the intent to cause pollution damage, or the person acted recklessly and with knowledge that pollution damage would probably result. The court held that because ABS performed services for the Prestige, ABS was another person performing services for the ship within the meaning of the convention. And in deciding the appeal, the court then went on to consider whether the pieces of evidence discussed would allow a case to be made of recklessness against ABS. And their firm conclusion was that they did not think that a reasonable jury could conclude on the evidence presented that the failure of ABS to take any action with regard to the Prestige was reckless. And the case hasn't quite come to an end because there is still pending in France a claim by French authorities against ABS in relation to the pollution damage along the French shores. So I hope you find that interesting. I think one of the things I wanted to mention, maybe for those younger members of the audience, younger than me, maybe starting out on their careers, I think I've been very lucky both to do the legal work that I have with Lloyd's Register, but also to work alongside a lot of expert naval architects and marine engineers. And some of them actually are literally world-beating in terms of their technical knowledge. And I'm reminded often that they have a really difficult task, both to agree standards for the construction or arrangements for the construction and the design of vessels, which maximize the commercial potential, whilst at the same time ensuring safety. And it's a very fine line that they tread. And actually a number of the cases that I've dealt with, what's obvious is that often operators, the Petronius platform is maybe the best example, they go over the limit. They overload it in the heat of the moment. They don't stick with the safety limit that's set out, and how important that is. So I've really appreciated working with the technical surveyors at Lloyd's Register, even though more than once they've told me the joke about the lawyers and the marine engineer. For those of you who haven't heard the joke, I'll tell it briefly. If you have heard it, apologies for you hearing it again. But the joke goes along the lines of Satan is one day called upon by God to send his best engineer up to heaven because God has got a problem with the heating system. So the engineer goes up and repairs the heating, or thinks he repairs the heating system in heaven and returns back to hell. But however, his repair really hasn't worked, and God is very unhappy and gets back in contact with Satan and says, look, that engineer you sent me is useless. He's done an awful job, and if you don't sort it out, I'm going to sue. And the devil says, well, sue if you want, but you don't have any lawyers up there. They're all down here. So thank you very much.
Thank you, Andrew, for a most informative and thought-provoking lecture. I am sure that there will be some questions for you at the end. But before we get to that, we would like to propose a formal vote of thanks. And I am delighted to say that tonight the honour of proposing the vote goes to David Stewart. As many of you will know, David is a full-time independent arbitrator and is the current president of the London Maritime Arbitrators Association. A graduate in law from the University of Cambridge, David qualifies as a solicitor and worked for 30 years in practice at our very firm, Ince, before he left in 2011 to pursue his arbitration career, and he now practices through arbitrators at 10 Fleet Street with specialisations in shipping and offshore energy disputes. David, over to you. Thank you.
Well, a very good evening, ladies and gentlemen. Thank you to Julian. Thank you to the Institute and INTS for inviting me this evening. Donald O'May was an expert in a community of experts. London is the preferred venue for international maritime dispute resolution and has been for a very long time, by a long way. And one of the main reasons why people come to London by choice is the existence of that community of experts. As the Lloyds insurance market developed, there grew up around it a body of expertise, not just in London, but in other parts of the UK, including, for example, Southampton. And a lot of that expertise is represented here in the room this evening: specialist solicitors, barristers, judges, arbitrators, academics, marine engineers, naval architects, cargo surveyors, and of course, class. Lloyd's Register plays an important part in two areas which were very closely associated with Donald: marine insurance and maritime disputes generally. In addition to their vital role in relation to safety and the services that they provide to underwriters and to the shipping industry, the classification societies also help to resolve disputes. We quite often see contracts, particularly in shipbuilding and offshore construction, where the parties have agreed to submit for resolution disputes to the classification society, where those disputes are technical in nature or relate to conformity with class. Some class surveyors, with their wealth of experience, go on to become expert witnesses or arbitrators. So it's very fitting that the Donald O'May Lecture this year should have been delivered by a representative of a classification society. And what a first-rate lecture it was. Andrew, it was fascinating to hear your very clear comparison of the common law and the civil law regimes. It was also, for me, terrific to get some personal and detailed insight into stories that many of us know only in very general terms. And you explained to us very powerfully why it's in the public interest that classification societies should not face an undue risk of litigation. So, ladies and gentlemen, may I invite you please to join me in expressing sincere thanks for an excellent lecture to Andrew.
So, ladies and gentlemen, I think we still have a little time. So if there are any questions from the floor, please raise your hand in the usual way. I think Claire has a microphone, so we can bring a microphone to you.
I shall have a go if nobody else does. My name is Aline de Bièvre, and I'm a retired maritime journalist. I wrote my whole life about IMO regulations, international maritime regulations. Mr. Kennedy, in the beginning you mentioned the issue of foreseeability of for instance, structural failure of a vessel as a result of a negligent element in a class survey. And then in that connection, you seem to say, I think, that in court, the threshold is very high to establish a convincing case of duty of care. So my question is, in the last 10 years, the IMO introduced mandatory goal-based standards for large tankers and bulk carriers, which the classification societies and the IACs are obliged to follow. So this is international law. if there is a case of a large tanker or large bulk carrier suffering damage as a result of a failure in the survey that did not meet these goal-based standards, do you think that would make it easier for a ship owner to convincingly establish a duty of care on the part of class? Because it's been very difficult for ship owners. Yes. And so I wonder whether this mandatory legislation of IMO on goal-based standards, which goes back about 10 years, whether that introduces a new element that may make it easier in inverted commas, for owners. Sorry for the long question.
No,
thank you.
Thank you for the question. I think I can best answer it by referring back to the French case, the Junior M case, which was decided solely on the basis of whether the French Supreme Court believed there was evidence that the class surveyor had breached the requirement. In Junior M, it was a class requirement. It could have been a convention requirement. And when there was evidence, so the outcome of that case would have been very different had the evidence been presented that the class surveyor had breached either a requirement of classification rules and regulations or the international convention. So when that happens, yes, the class is at risk, and then the other factors will be looked at, but it makes class much more at risk of a financial liability.
Thank you. Excellent question. I think there's another question just a bit further down the room.
Do you think the speeder would be decided the same way by an English court?
Yes, quite possibly, because there was sufficient proximity deemed to be in place between NK and the buyer, and NK knew when it issued its certificate that it was going to go to the buyer, and the buyer would take delivery on that basis of a class certificate without recommendation. And at the same time, there was the evidence of quite a number of deficiencies on the vessel. So I think that there would be a real risk for class in England in those circumstances.
Do we have any other further questions from the floor? Don't be shy. I think you might be free. Well, ladies and gentlemen, in that case, may I, on behalf of the Institute and of INS, thank you all so very, very much for attending this evening's lecture in the memory of Donald. I think we all agree we've had a fantastic presentation, and I believe we have some drinks, so please do stay around and have an opportunity to network with each other and get to see each other, and also to, of course, have a chance to speak to Andrew and David in more detail. And could I just ask one final request? Can I ask you to again thank both Andrew and David in the usual way? Thank you.